Hello, welcome to our final lecture for this semester, Masterpiece Cakeshop, the Colorado Civil Rights Commission. Very recent case dealing with a lot of important issues, tensions that we'll see that are still relevant to today's cultural discussions regarding gay marriage, rights pertaining to certain protected classes of people. This is, of course, from a Christian worldview, so we will dive into the material. We will look at the judicial opinion, but we will ultimately found a lot of our opinions and beliefs about this case from our Christian beliefs and our Christian faith, much like Jack Phillips did in this case as well. So it's important concept. The pertinent facts took place in 2012. It wasn't until 2018 that the Supreme Court rendered this opinion. I'm recording this in 2023, and a lot has happened since 2018 even. It's just amazing the speed at which our society is moving. Degrading to some extent, deteriorating, but then also building and doing wonderful work in other parts. So I think it's important for us to focus on the reasoning, the analysis that the court brings to best equip you for wherever you go from here, from this class and from your academy or program or whatever your current educational platform may look like, knowing that this is a hotly contested issue, right? The rights of certain protected people and how far those rights extend, especially when they run against a person's deeply held religious convictions, as we'll see in this case. So let's jump into the facts. We have Mr. Jack Phillips. He's the owner of Masterpiece Cakeshop in Colorado. He makes cakes, wedding cakes, and there was a gay couple that came into his shop one day requesting that he make a wedding cake for them. He refuses on his Christian beliefs. He has deeply held, sincere beliefs that marriage is between one man and one woman, and he takes the position that he has a right to exercise his religious beliefs through free speech or otherwise, which would include making a cake, his artistic creation. So what happens? Inevitably conflict, right? So on one side we have Masterpiece Cakeshop, but on the other side it's not so much that these gentlemen are suing or attempting to sue Mr. Phillips through his business, Masterpiece Cakeshop. Rather, they file a claim with the Colorado Civil Rights Division complaining of Masterpiece Cakeshop's practices of discriminating against them based on their sexual orientation. So, what that means for our purposes is we need to understand what public accommodation laws look like and what they mean and how they navigate in this tension between protecting certain classes of people, like we saw in the Dred Scott decision, right, and all the implications from there, Brown v. Board of Education, what they were attempting to do, and getting into the protection, on the one hand, the protected classes of individuals, and on the other hand, freedom of expression, right? That freedom of thought, belief in and deeply held religious beliefs. So here we're dealing with the Colorado Anti-Discrimination Act. You'll see it throughout the opinion, CADA or CADA, whatever it may be. And I thought it was important for us to just read this and think about this law. Not every state has a public accommodations law, which is what this one is considered to be. So it says it is a discriminatory practice and unlawful for a person, directly or indirectly, to refuse, withhold from, or deny to an individual or a group because of disability, race, creed, color, sex, sexual orientation, marital status, national origin or ancestry, the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of a place of public accommodation. So, several things to pull out of there. Let's just start with the principle that it's creating a illegal act. So, if this law wasn't in place, in other words, there would be common law, there'd be judge-made law to sort of reconcile. But this is Colorado law. We'll see the citation down here, Colorado statutes. And it's got this nice little string citation here. Actually, that's not technically a string citation. I should watch my language very carefully. It qualifies where one can find this in the Colorado statutes. But for our purposes here, we're looking at this and recognize that Colorado, their legislators, basically came together and said, look, this is going to be a law. If it's a place of public accommodation, which is important to point out, public accommodation, then it is unlawful for that person to indirectly or directly refuse or withhold or deny someone basically the opportunity, the enjoyment of the goods and services based on any of these protected classes. Now, I'm not certain, just right off the top of my head, if we've talked about protected classes. Race is a really easy one to point out and think through. We had the Plessy v. Ferguson case, right? There was the rail cars, and that was probably considered a public accommodation. We wouldn't necessarily have that language to work with, but if you can envision, again, there was the black car and the white car, for simple example. And the law was on the books stating that if you were non-white, anything other than a white race, you had a certain car to sit in. And if you were a white person, then you had your own car to sit in. There's a separation of the two. But that's where the principle of separate but equal came from, right? Here's a public accommodation, namely the rail car, and so here is how that separation will occur. Again, whether it was equal doesn't really matter now, but they were in fact separate. So what this public accommodation law will do, and again, several states have it, not all states. Texas, for example, does not currently have a public accommodation law. Would say that any sort of public accommodation must be open or cannot be denied to anybody, any individual, based on disability, race, creed, color, sex. So those are sort of the standard protected classes. But then now we also are adding sexual orientation, marital status, national origin, or ancestry. I guess national origin and ancestry don't really, they kind of fall in line with the other protected classes, but sexual orientation is particularly the focus of this case. So, there's kind of a jumbled bunch of thoughts there. Let's get into public accommodation. So public accommodation is basically any place that is open to the public for goods or services to be sold. There on, what page are we on? 1725. The Act defines public accommodation broadly to include any place of business engaged in any sales to the public, in any place offering services to the public, excluding church, synagogue, mosque, or any other place that is principally used for religious purposes. So basically, if you have your doors open to the public, like a store, that's a really easy one to pick on, then this law applies to that store. You cannot see someone walking up that would be, let's say, for example, of a different race and say, oh, no, you don't. You can't come in this place. Try again. That will be deemed discriminatory and unlawful. So then, of course, come with certain fines, punitive damages, perhaps. That's easy to pick up. But now we're looking at this and saying, look, the laws on the books that say even sexual orientation. So if there is a gay couple, for example, coming to a store that is open to the public, that store owner cannot say, we do not allow gay couples inside this store. You know, go down the road or try across the street. We do not accept it. Nope, can't do that now. Maybe they could before, but again, law on the books. That's what we're focusing on. because now it's unlawful, it's illegal. It comes with certain damages, certain punitive damages, namely the prosecution of that store owner, as we'll see here in a minute. So all to say, public accommodation exists more or less on this spectrum here. So let me jump ahead real quick. So there's this concept of a private residence versus a public accommodation. So we're thinking about a public accommodation, picture like a mall, right? I don't actually know if malls are still around, if people still go to malls, but any sort of store that would be open to the public, big name stores, I mean, those are easy just to think of. It's not they're the only kind of a public accommodation, but they're easy to think about. Restaurants, right? Restaurants are open to the public. People come in, they get services, they get food, they pay and they leave. It's not an invitation-based business, right? It's not like a private residence. Go back real quick, where it would be your home. So, for example, I own this home. It's my home. I get to decide who comes into my home. Now, okay, exceptions to that. Law enforcement, it's easy to come to mind if there's a warrant, whatever else it may be. But generally speaking, it's my home. I get to decide who comes in here, and I can deny anybody access to my home because it's my private residence. I don't open it up to the public. I'm not letting anybody just walk in and out. I'm not offering goods and services out of my home. This is my home. This is my private residence. But if I had a restaurant, for example, that I let anybody come in, right? It's a public accommodation. And again, I guess in this example, I'd have to be situated in Colorado, or at least a state that has a public accommodation law. Then I could not deny someone based on race, their creed, their sexual orientation. Again, the whole list of things we just saw. Disability, race, creed, color, sex, sexual orientation, marital status, national origin, or ancestry. So that is the law in the books. That is the rule that we're looking at. That is what ultimately becomes the issue, because here is the tension that we're dealing with. This court points this out as far as what they have to reconcile. So on one hand, there are the rights of these protected people. The country has the history of denying certain classes of people fundamental rights. Let's go back to the Dred Scott v. Stanford case, right? The court said the man was not a man. The man was considered chattel, and so they didn't have jurisdiction to hear the case. Moving forward even to Plessy v. Ferguson, right? Okay, you know what? We're going to keep a separate but equal policy in place. So black people, here's your separate rail car, and white people, here's your separate rail car. Even getting to the Sweat v. Painter case, same sort of principle there. Of okay, look, we're interested in the rights of protected people, namely people of minority race, but we're going to wrestle with a tension in those cases with regard to long-standing tradition, relatively speaking. So in this case, that's on one end, right? Well, that is one end. The rights of protected persons, in particular, gay persons, those of homosexual orientation. And then on the other hand, we still have the exercise of First Amendment rights. So we have store owners, business people, that would still have the ability to communicate and practice their deeply held religious beliefs. So now the issue comes down to, well, okay, is this creation of cake, when Mr. Phillips is creating these cakes, is that considered an exercise of First Amendment protection, right? Is that his freedom of speech to be able to communicate with these cakes? And so if he's not, or excuse me, if he is creating cakes that violate his deeply held religious convictions, then we would say that the government is abridging his rights. Yeah, let's just pull out the First Amendment again. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people to peaceably assemble and to petition the government for a redress of grievances. The state has legitimate interest in protecting the rights of protected classes. That's what we call, again, that kind of laundry list. Disability, race, origin, sexual orientation. Those groupings of people are protected classes. Now that group, or that list, I should say, of people seems to be expanding. Right? We have transgender individuals now that could possibly be thrown into that class. Any sort of mental disability. I mean, there's just a whole range of protected classes now that our society is currently trying to navigate through and figure out really what to do with this recent development in our society, the way we think about people and the adjectives ascribed to them to box them in essentially to protected classes. We'll kind of get in that toward the end of this lecture, but for now, let's again situate ourselves. It's 2012. Obergefell case came out in 2015. Colorado at this time did not recognize gay marriage. And now we're situated in 2018, post Obergefell, which found a constitutional right to same-sex marriage. So we're dealing with the rights of protected persons in and seen through, codified by the Public Accommodations Law. And we're balancing that with the right to speak freely based on one's deeply held religious convictions. Again, Mr. Phillips was a devout Christian. He had beliefs in biblical marriage between one man and one woman. He would argue, and he did successfully, that his creation of these cakes are in fact speech that should be protected by the First Amendment. We know there's a spectrum now, right, between those two tensions, protecting the rights of certain persons based on their class, and First Amendment protections to speech, to deeply held religious beliefs. We're reconciling those two things, and we know that there's generally a spectrum that all of this is situated in between the private residence and a public space or public accommodation. So now, where are we at? Well, procedure. Procedure is very, very important. I don't, necessarily want to belabor the point here, but I think it's worth walking through this maze to understand really what happened, quite tangibly what happened, because the court points to this level here at the Colorado Civil Rights Commission as to really what went wrong, how this case got so far off the tracks that the Supreme Court felt obligated to ultimately rule in Mr. Phillips' favor. So the aggrieved parties, Craig and Mullins, filed a complaint with the Colorado Rights Civil Division. So this was just the scheme that Colorado had in place for persons that were perhaps aggrieved by given businesses illegality or discriminatory practices via the Public Accommodations Law, via the Colorado Anti-Discrimination Act. So they filed a complaint here, and the Colorado Civil Rights Division ultimately has to open up an investigation to determine whether it's worth pursuing or investigating further. After investigating further, the Civil Rights Division would then report back, or really up to, the Colorado Civil Rights Commission. Now, the Commission would make the decision as to whether it was worth following up. So they would send it up to the administrative law judge, a state official, basically, to determine the merits of the case. And then the administrative law judge would decide whether it was worth referring back to the full panel, the 7-member panel at the Colorado Civil Rights Commission. It was here that the issue really got, or the discussion really got messy. So going back to the scales, right, the scales of justice, the commission should have approached this issue from a neutral perspective, right? The court gets into that a lot, so we don't necessarily need to to dive into that concept. But for our purposes, the court, pseudo-court, should be approaching this as, okay, state has legitimate interest in protecting the rights of protected classes, but on the other hand, there are legitimate First Amendment rights that a business owner like Mr. Phillips is entitled to via his deeply held religious convictions. Rather than approach that neutrally and try to wrestle with that tension, it was almost like they were making fun of his religious beliefs, right? They were not being neutral, in other words. They were being very biased and perhaps prejudiced towards Mr. Phillips because they had already made up their minds that if you're on the wrong side of this complaint promulgated by a gay couple, then that other person, right, the one being complained about, must be in the wrong. So they rendered that decision against Masterpiece Cakeshop. Mr. Phillips decided to appeal that decision up to the Colorado Courts of Appeal. Same sort of outcome, right? You can read about that in the case as well. Then decides to appeal it to the Colorado Supreme Court. That would be the highest court within the state of Colorado. I think they denied hearing it because they just didn't need to jump in or didn't want to jump in, what it may have been. And so then he petitioned the United States Supreme Court to hear this case, the court of final jurisdiction. Supreme Court granted it, which is why we have this case. So again, 2012, we're down here starting this case. And it's not until 2018 that the Supreme Court finally renders a decision. So a very long process to go through all of these hoops. But it's important to recognize that this isn't a flippant decision. It may have looked like a flippant decision down here, which is really what the Supreme Court points out and wrestles with and analyzes. But I think it's dangerous in our modern times to think that the Supreme Court somehow is just waiting right in the middle of a very contentious subject matter. Now, open for discussion. Right? I'm not affixed to that point. I think there's plenty of examples in which the Supreme Court, rather than saying, again, emphatically what the law is, see Marbury v. Madison, the court seems to jump in the middle of a hotly contested issue, and rather than try to figure out what the law is, they may push themselves on one side or the other, rather than perhaps letting the legislative process solve this by promulgating new laws. Now, that was a caveat, but let's just recognize here, though, a long process, lots of procedural hoops to jump through, big old maze to get all the way up to the Supreme Court. Again, this relatively small issue of a cake, right? That's still the fact of the matter, but it's the implications from these two competing interests, protecting the rights of given classes of individuals and protecting First Amendment rights. And those two butt heads, that's really the nature of this case. So, court gets into a lot of discussion regarding equality and particularly of homosexual individuals. We're to a point in our society where they should not be considered outcast, and that they should perhaps or are considered a protected class of individuals. So almost in the same way that we could look back to the Dred Scott decision, for example, and think, what in the world? How in the world could you deny a black man's right to petition the court for his freedom? Why in the world would that be the case? And you sort of have this chronological snobbery, to use C.S. Lewis's phrase. The court goes ahead and almost without much analysis makes these conclusions that gay people and homosexual individuals have been social outcasts in our country and across the world for perhaps a very long time. And so it's worth protecting those groups of people in the name of equality. So in other words, there's a lot to be said for this public accommodation law. It's not that the law is necessarily bad. In fact, the court may even say that the law is good. It's a good thing to have that law, to not discriminate against persons of different sexual orientation that would normally be a social pariah or social outcast, and qualify these people as a protected group of individuals worthy of protection under the law. It's a good principle, I think, to wrestle with. On one hand, I think it's okay for us to recognize that public accommodation law aims to provide protection, right? We don't want a society in which entire groups of people based on skin color, race, creed, national origin are denied certain services. And we, I guess in that way, we want to use it as a shield, right? Protect those people. But at the same time, too, we don't want to use that same law as a sword. We don't want to use that law as a way to attack people that may have a different belief regarding the legitimacy of perhaps a marriage between two people of the same sex. That's the tension. Right? That's the underlying tension here. So Mr. Phillips is a Christian. He's a devout Christian. And point to his Christian faith is the reason for his business. Right? His Christian faith wasn't separated from his business. When he was creating the cakes, it was an extension of him. He was expressing himself and his deeply held beliefs through these cakes. So like the wedding cakes, for example, that he'd make for a man and a woman getting married, that would be an expression of his belief that a marriage is in fact between one man and one woman. The court is able to look at that and say, okay, yep, this is speech, right? This is his manifestation, his expression, his creation through his business is in fact speech that would be protected by the First Amendment. Tension's still there, though, right? Tension is still there between, we have a group of people that are normally outcast in our society, or have been, I should say, and a business owner's right to express himself, to convey certain messaging. He shouldn't have to give up or be prevented from expressing himself accordingly, and should not be compelled to make a certain cake that would otherwise violate his deeply held religious belief. Here on, what page is this? 1727. It's where this sort of overview, historical analysis, or societal analysis, I should say, comes up. The court says, nevertheless, while those religious and philosophical objections are protected, it is a general rule that such objections do not allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services under a natural and generally applicable public accommodations law. So their tension there is still largely unresolved. They get into the details then of how the Civil Rights Commission attempted to reconcile that tension. So it's not, let me just pause there. It's not as though the Supreme Court said, yep, religious belief will trump protecting groups of homosexual individuals. No, right? They say public accommodation law is good, generally speaking, but it doesn't come necessarily at the expense of having to give up religious and philosophical beliefs and those practices. So it's the way in which one approaches that tension that matters the most. They have to come from a place of neutrality, and if they don't come from a place of neutrality, then the likelihood of someone's First Amendment protections being violated is all the higher. So they look at the nature of this case, they look at the discussions that took place, and it was sort of comical. If you read that part of the opinion or the comments that were made about Mr. Phillips' Christian beliefs and Christian faith. The Supreme Court here are looking at it, and it's almost like they're making light of his political opinions. I think at one point they say that, the commissioner even went so far as to compare Phillips' invocation of his sincerely held religious beliefs to defenses of slavery and the Holocaust. Again, the kind of chronological snobbery, and how do we reconcile that? Such that there was no neutrality. There's no neutrality, like giving Mr. Phillips sort of a benefit of the doubt almost. If we really approach this and said, okay, you know what, your deeply held religious beliefs are true and good, but then we also want to protect certain groups of individuals, how do we reconcile those two? Then it may look more neutral in scope and approach of how they did this. But the Supreme Court points out that no, the Colorado Civil Rights Commission, when they were reviewing this and investigating this and trying to determine whether there was a violation, whether there was discrimination that took place that would merit punishment and fines of Masterpiece Cakeshop, they did not approach it from a neutral perspective, and so there was no resolution of the competing tensions, right? There was no resolution, an attempt to reconcile these two competing interests. So, court really parks itself there. It doesn't give us much direction. Right? It doesn't give us much resolution as far as how these two competing interests should be resolved or ought to be resolved. We have here the church, the Lukumi Babalu Ai, which, if you remember back in the Reynolds case, referred to this case regarding what do you do with animal sacrifices. So if you look that one up, it came back up here in the Masterpiece Cakeshop case. But here on 1731, I believe. So in that case, the court made clear that the government, if it is to respect the Constitution's guarantee of free exercise, cannot impose regulations that are hostile to religious beliefs of affected citizens, and cannot act in a manner that passes judgment upon or presupposes the illegitimacy of religious beliefs and practices. So again, the Colorado Civil Rights Commission was really approaching his beliefs, his religious beliefs, Mr. Phillips' religious beliefs, from a place of his religious beliefs are wrong. They are not right. And so, of course, any sort of pushback on the belief of the legitimacy, perhaps, the legitimacy of gay marriage, in their minds would automatically be wrong. Right? They are presupposing that if you have any sort of belief that is not in line with the legitimacy and celebration of gay marriage, then those beliefs are ultimately wrong. So because they approached it from that sort of biased perspective, then they violated the principle of neutrality as was established in that case. And then we're left with this conclusion, basically, that leaves everyone questioning, right? We don't know really how to still reconcile those two. So in other words, if I'm a business owner and I have, let's say I create cards, greeting cards or invitation cards for weddings, that's just the nature of my business. How do I know, and again, if I live in Colorado or any other state that has a public accommodation law, how do I know I won't be compelled to print those cards that would violate my belief that marriage is between one man and one woman? The court leaves us with this conclusion, and it was ultimately a foreshadow. The outcome of cases like this and other circumstances must await further elaboration in the courts. all in the context of recognizing that these disputes must be resolved with tolerance, without undue disrespect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in an open market. So TBD, basically. What are we going to do about this tension? How are we going to resolve this tension? We got to wait and find out. We got to see what's going to happen next. So if I'm a business owner, and that's the nature of my business, is to print these cards for weddings, invitations, greeting cards, whatever else it may be, and I have this deeply held religious belief, if I'm out in the open market, then am I going to be compelled to provide invitations to a gay wedding? Am I going to be forced by the government, by the state, to make these cards, to write out invitation cards in violation of my deeply held religious convictions? Well, I have First Amendment, right? I have that to couch a lot of my arguments on. That would say, no, absolutely not. I do not believe that. You cannot force me to say that. My greeting card business would be expression of speech. So we have the First Amendment to rely on. But it's still not clear whether that would then violate the public accommodations law. And we don't know if that would be discriminatory of me to be open on the marketplace, allow anybody essentially to come in and offer money in exchange for my services, right, a business. And so what are we going to do about that? The Supreme Court really hasn't left us with any clear guidance. Well, we still, glad I put that in there. That's the tension. We still have this tension, right? We still have this balance that we don't know what to do with. What we do have now is this 303 creative case that, came out June 30th, 2023. Brand new case that attempts to answer this, and attempts to give more clarity with regard to this tension between the rights of protected persons and the exercise of First Amendment rights, and what sort of protections are afforded to both via the Constitution versus public accommodations law. If you're interested in this subject matter, I would encourage you to just go and read that case. I think it's really well written. I think it would cover a lot of the topics that we've covered in this class that would hopefully engage some self-directed learning and some self-directed answers as well. So, for our purposes here, that is Masterpiece Cakeshop. It's a very, I think, important case, but nevertheless a confusing case. It attempts to reconcile these two very, very highly sought-after rights, but doesn't really give us much clarification on how to resolve them. The court had a way to look at this and say, look, you didn't approach this from a neutral perspective when you were considering Mr. Phillips' deeply held religious convictions. It was almost as if you presupposed he was in the wrong, and so there was no adjudication between these two competing interests. So try again, basically. And then we have, the 303 case that would help expand this concept, but for our class, we're not going to cover it. If you're interested, by all means, read it. By all means, dig into it. Happy to ask or answer any questions you may have when you do read it. But I wanted to go ahead and throw this case in here at the end to show that even though we have come all the way from Marbury v. Madison to this Masterpiece Cakeshop case, there are still issues, right? They're still going on that require legal analysis, that require legal reasoning, and ultimately require the defense of deeply held religious convictions. Right? It's not enough to think that we have the First Amendment to rely on when it comes to our Christian faith. There will be more and more instances where these two competing interests butt heads and cause turmoil and require the reconciliation through the courts and through the judicial system. But I would wager that this side of the equation will more or less outweigh this side of the equation within a period of years. It seems to be the way that our society is moving and going towards. So it's important for us as Christians to recognize that yes, we have the Constitution, and yes, we have the First Amendment, and yes, we've done a very good deep dive into the First Amendment protections afforded. But at what point in time do things like public accommodations law start to take more and more precedent over First Amendment protections, namely protection of the practice and exercise of our religious beliefs? We're not going to solve that, right? We're not going to solve all that right now, but I wanted this to be the last case we covered so that we know that there's a mission still to be done, right? The Great Commission is still in place as we go to the ends of the earth, to all nations, and recognizing that the extent of our constitutional protections are not a Christian's end-all, be-all. That it's not the authority that we have as Christians to be Christians, right? We don't point to the First Amendment to say, that's why I get to be a Christian, that's why I get to have my beliefs. We have something much more important, right? Much more powerful, much more enduring, too, that enables us to have confidence as our society moves further and further away from true, the good, and the beautiful. In conclusion, I hope this has been a great experience. I hope that this has been helpful. I hope that this has been able to bring up a lot of questions and help you apply your phenomenal education in a very real sense, in a sense that I hope will stay with you for the years to come. If you ever do find yourself interested in law school, please email me again, look me up, whatever it may take. Love to have a conversation with you. I have a guide as well. I think I've mentioned that in a previous lecture too, that may be helpful to make that sort of decision. I think that practice of law is a phenomenal opportunity to exercise a lot of these great concepts, especially if you've really enjoyed your classical education. But more importantly, I think it's just a matter of growing where planted. So wherever the Lord may direct your life, I pray that you will be faithful in using this phenomenal education and the resources available to you to make the most of it, to grow where planted, to work where your feet are, and to ultimately build your sectional wall, as we know in Nehemiah. So all I'd say, we'll talk more about the final. Any questions about this case, anything else that may come up, please let me know. Please reach out. Until next time, I'll see you then.